Hello everyone. This lesson concludes our discussion on nature and effect of obligations. In this lesson, I will be discussing fraud as understood in Article 1171, negligence as found in Article 1172, and the concept of usury as mentioned in Article 1175. Article 1171 provides that responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. The fraud in Article 1171 refers to the fraud in the performance of the obligation and not to the fraud in the execution of the contract. It is the intentional evasion of the normal fulfillment of the obligation. Responsibility arising from this kind of fraud is demandable in all obligations. This means any deliberate deviation from the normal way of fulfilling the obligation may be a proper basis for claim for damages against the guilty party, but the contract itself will remain intact and valid. The problem lies only in the implementation and not in the execution. The law does not allow any waiver of any action for future fraud. Any such waiver is void. To allow such waiver will necessarily render the obligatory force of contracts illusory. Parties can simply disregard their commitments without fear of reprisals. However, the law does not prohibit waiver of an action for damages based on fraud already committed. After a party has been defrauded and he wants to forgive the other party, that is his own concern. The law will not stop him. Article 1172 provides that responsibility arising from negligence in the performance of every kind of obligations is also demandable, but such liability may be regulated by the courts according to the circumstances. In determining the liability of a party for damages resulting from his negligence in the fulfillment of contractual obligation, the courts have discretionary power to moderate the liability according to the circumstances of the case. Using their sound discretion, courts of justice may increase or decrease the liability of the parties who are at fault, depending upon the attendant circumstances in each case. The good or bad faith of the obliger may be considered as well as the conduct or misconduct of the obligee. When both parties to a transaction are mutually negligent in the performance of their obligations, the fault of one cancels the negligence of the other. If the obliger acted in bad faith, he is responsible for the natural and probable consequences of the breach of contract and which the parties have foreseen or could have reasonably foreseen at the time of the constitution of the obligation, as provided for in the first paragraph of Article 2201. In case the obliger is guilty of fraud, bad faith, malice, or wanton attitude, he shall be responsible for all damages which may be reasonably attributed to the non-performance of the obligation, as provided for in the second paragraph of Article 2201. What is the effect of contributory negligence of the obligee on the liability of the obliger? If the obligee's own negligence has merely contributed to his own injury or damage, the effect is the reduction or mitigation of the liability for damages of the obliger. It must be noted that if the negligent act of the obligee was the proximate cause of the event which led to the injury or damage complained of, the obligee cannot recover any damages. Now, let us distinguish negligence from fraud or dolo. In negligence, there is no deliberate intention to cause damage or injury, even if the act was done voluntarily. In fraud, there is a deliberate intention or plan to cause damage or injury. Now, let us move on to the topic on usurious transactions under Article 1175. Article 1175 provides that usurious transactions shall be governed by special laws. Usury is the act of lending money at an interest rate that is considered unreasonably high or that is higher than the rate permitted by law. Since the effectivity of Central Bank Circular Number 905, usury has become legally non-existent in the Philippines. The absence of the law that regulates usury, however, does not mean that courts are powerless to decrease or nullify exorbitant interests. Unconscionable interest may be reduced under Article 21 of the Civil Code for being contrary to morals. In the case of Medel et al. Versus Court of Appeals 299 SCRA 481, the Supreme Court made this pronouncement. The usury law is now legally inexistent. We agree with petitioners that the stipulated rate of interest at 5.5% per month on 500,000 loan is excessive, iniquitous, unconscionable, and exorbitant. However, we cannot consider the rate usurious because this court has consistently held that Circular Number 905 of the Central Bank, adopted on December 22, 1982, has expressly removed the interest ceilings prescribed by the usury law and that the usury law is now legally inexistent. The Supreme Court, however, continued. We find the interest at 5.5% per month or 66% per annum stipulated upon by the parties in the promissory note iniquitous or unconscionable and hence contrary to morals, contra bonus mores, if not against the law. The stipulation is void. The courts shall reduce and equitably liquidated damages, whether intended as an indemnity or a penalty, if they are iniquitous or unconscionable. In another case, the Supreme Court said that a stipulation in a promissory note which gives the bank authority to increase the interest rate at will during the term of the loan violates the principle of mutuality between the parties. While the usury law ceiling on interest rate was lifted by Central Bank Circular Number 905, nothing therein could possibly be read as granting the lender carte blanche authority to raise interest rate to levels which would either enslave its borrower or lead to hemorrhaging of his assets. This ends our lesson on the nature and effect of obligations. Thank you for watching and see you again next lesson.